Good evening. Hi, I am Marla Williams. I am an attorney with the Legal Aid Society of Middle Tennessee and the Cumberlands. I work in the Cookeville, Tennessee office. I have been with Legal Aid several years and am currently the lead consumer attorney for all the Legal Aid offices. And with me is Ben Burdett, and he will tell you a little bit about himself.
Hi, my name is Ben Burdett. I work in the Oak Ridge, Tennessee office of the Legal Aid Society of Middle Tennessee. I most of my job is doing the most exciting kind of legal work there is, tax law. But I also sometimes help people with exactly the kinds of cases that we're going to talk about today, where they're having trouble with being ripped off from a car that they bought or something like that.
Yes. First, I want to tell you a little bit more about legal aid, other than the fact that both Ben and I work for legal aid and we're both attorneys. Legal aid is a 501c3 private nonprofit law firm. We represent in civil matters only, and I guess the most important distinction is we don't handle any criminal law matters, and we handle civil legal matters that, for the most part, the private bar does not handle or doesn't have the capacity to handle. So, and we represent low income individuals and families and the elderly population who cannot normally afford legal services. The Legal Aid's mission is to advance, defend, and enforce the legal rights of low income and vulnerable people in order to secure for them the basic necessities of life. We have a pretty large service area for the Cookeville office. We serve 10 counties, and in fact, our whole firm covers, I think, about 45 counties in Tennessee. Ben, how many counties does the Oak Ridge office cover?
Looks like 7 to me.
Okay. All right. And in our service area for our particular legal aid society, there are over 440,000 individuals who live at or beneath the federal poverty line. Um, so there's one of us legal aid attorneys for every 13,000 Tennessee citizens in our service area who might need our services. And there you can see our areas of practice, not only consumer protection law, which the issue with cars and purchasing cars that don't work falls under, but we also have the capacity to handle some bankruptcies through our volunteer lawyers program. We deal with special education and other education issues, elder law, employment, mostly unemployment compensation, family law and domestic violence, health law, housing, immigration law, juvenile law, mortgage foreclosure, public benefits, and tax disputes. and you'll also see where we serve, and we have 8 offices in the state of Tennessee: Clarksville, Gallatin, Oak Ridge, Tullahoma, Columbia, Murfreesboro, Cookeville, where I work, and then our um, administrative office is in Nashville. I'd like to start off by saying that the information that we provide, that Ben and I tell you or you read in the presentation, is only information. It does not take the place of legal advice. And this is because each case is different and needs individual attention. So what we tell you again is general information. It may not apply to your particular situation, but we will tell you how to reach us to ask about your specific fact situation and what law applies to that. So this is an overview. The question that we like to answer for you to give you information about tonight is how can you avoid being stuck with a terrible car that you just bought, and you may or may not believe how often that happens. We see cases where a consumer, who would be maybe you, buys a vehicle, and unfortunately, they might immediately live or are going 10 miles away from the dealership where they purchased the vehicle, and it breaks down on the way home. Um, so the cars sometimes that they buy are terrible. And the short test drive and just visibly looking at the vehicle does not reflect that the cars are terrible. So the first point that we want you to know, 2 points to start off with. One is to do your research before you buy, and number 2 is know your legal rights after you buy. Okay, before you buy. There are several things you can do before you buy, and it's not a good idea just to go on the lot and purchase a car as soon as you see it. You should look into, get all the information that you can before you purchase a vehicle. And there is no reason that a dealer should not allow you to copy the VIN number or get any information about the vehicle before you decide to buy it. And so one thing you can do if you have the VIN number is to order a Carfax report. And those can be found and printed online at www.carfax.com. And like I said, they can give you the, you can find that with the VIN number. Another thing you do is a test drive, and that's just not around the block. You should insist upon test driving it for the vehicle for a number of miles before you purchase it. Another good point is don't be pressured. And that you might hear, well, if you don't buy this car right now, we've got somebody else who's coming in this evening who's going to buy it. So if you want it, you better take it now. Don't buy that. Don't buy that. Those comments. You should take your time and again, not be pressured. And finally, you can check the Kelley Blue Book value, and that's also free and is available online. Now, if you have bad credit or no credit history at all, it's even more important to do your research. The individuals who are most likely preyed upon by a car dealer for the sale of a horrible or terrible car are more often low-income people who they might see as being desperate, and they want to pressure them to to buy a car because they may know that they might not qualify for a loan through a just a bank. A lot of people buy cars just that are financed on the lot rather than getting a loan from a bank that they have to be approved for. So some car dealers know that, so they are more often to prey upon people who don't have good credit or have no credit at all. And also, those dealers often overprice their cars um, because, again, they sense that the individuals who come to their lots are desperate for a vehicle and they can't be approved for financing for a new car, and just a regular bank or other lender may not loan them the money because of their credit.
I've had plenty of clients who come in, and then as part of a tax lawyer's work, for various reasons, I'm often looking at a client's financial situation and figuring out their financial health. And I've got so many clients who have bought a car where the Kelley Blue Book value is thousands of dollars less than what's on their loan. It's hard to make your way through life when you're buying cars that are twice as expensive as they should be. And if you're not checking the Kelley Blue Book value before you buy, you're going to get into some pretty bad deals if you're on a buy here, pay here lot. That's for sure.
Okay. Next thing is something that we see a lot of the times is we get a phone call or someone comes into our office whose vehicle has been repossessed. And we, of course, want to see the transactional documents before we can give any advice at all. Because the paperwork is, of course, the client's story is important, but also the paperwork is very important. What you signed, what documents you were given. But sometimes and most of the time, if the vehicle is repossessed, the documents, the transactional documents, were left in the car, so the client does not have those documents. So we would suggest a good tip for you would be not to leave the contracts or any other documents regarding the purchase or any repairs you've made. Anything regarding the vehicle should not be left in the car, other than proof of insurance and your registration. You probably know those two pieces of information are required to be kept in the vehicle or kept on you, so that if you are pulled over, you will have that information to show to law enforcement. So keep your contract. Certainly don't throw it away. We will need to look at that information. And, they're hard to read. So that's the thing about having the original documents. If you have a copy of your originals, those are most, are we are better able to read those than a copy we might get later on from that is furnished by the other side. So we like to see what you have, what you've been given, because, and another point is that if there is some controversy about the car purchase, including the condition of the vehicle, and we have to contact the other side, the dealer or their attorney, or we might not get the exact documents that the consumer was given at the time of the transaction. So keep all your papers regarding the transaction. And like I said, any subsequent repairs or anything, estimates, anything you have regarding the vehicle, keep those with you, not in the car.
And that last bit there about reading the parts with numbers, we've had clients where the client will come in and talk about the fact that they thought their trade-in was going to be X amount of money, and then the written contract turns out to be for Y amount of money. Contracts are really long and overwhelming, but the one thing that you should read on them is how much you're getting for your trade-in, how much you're paying on the new car, what that all works out to you. Um, you don't have to read everything. It's probably not going to help you to read everything, but read the price, read the even no matter what you've been told by the salespeople and the finance people, read what's down on the paper because the numbers on the paper are what's important.
Right. We have had folks contact us after getting home or even months later who said the dealer told me we would get, or told us as a couple, it was a couple, they told us that they'd give us $6,000 for our trade. And we were just looking at our contract and they only gave us 2,000 or 3,000. So practice what Ben said and read, because and contracts and other documents are just going to be shoved in your face, but you have the right to take your time and read those. And if a salesman or any other person at the dealership gets upset by the fact that you want to take your time and read those, that's a sign that you should not sign those. Okay, so my car turned out to be no good. Can I return it? There is the default rule, which we'll talk about. Question is, what does the contract say will happen if it turns out to be no good? Do you have a warranty? And next, the legal concept of revocation of acceptance. Okay, first, the default rule. The general rule is when you buy a car, the sale is final. So when you sign the contract and you drive the car off the sales lot, you are considered to have purchased a vehicle, and that sale is final, and you are considered to have accepted the vehicle. Next, we said we talk about what the contract says. Your contract might say the car is sold as is, and we see that in most used car cases. This means as is, that the seller is saying no return, even if the car is totally junk. The contract may say that there are no warranties whatsoever on the car. That's not necessarily true because there are some warranties provided by law. If the contract doesn't say these things, you may be able to return the car if it is broken. And you can may be able to return it if it's broken, even if the contract says those things. Did you buy a warranty? And if you purchased a warranty, it may mean something. It may not mean as much as you thought it did when you purchased the warranty. Most warranties that you purchase when you purchase a used vehicle are limited warranties. So if the dealer sold you a warranty or service contract, and those are two different things, service contracts and warranties both can be Of course, the dealer can sell you a warranty that the dealer covers, but it also can sell you a warranty from another company. Service contracts are the same, but they're most often a contract with another company that the dealer arranged. Um, and if a service contract or warranty is sold with the vehicle, the dealer may still advertise and sell the vehicle as is. However, it's really not as is because you have a warranty and or a service contract. So, as is typically means that all the responsibility is upon you should there be the need for repair. Um, but again, that's not true if you have a warranty or service contract because there's a an arrangement for another company to cover at least a portion of the cost of repairs if it unless there is some reason, unless you violated some part of the contract where um, it does not cover the repairs. And sometimes we've seen cases where a client purchases a vehicle, they have a service contract. Most often, those service contracts require that the oil be changed at regular intervals. You have to meet certain conditions to keep the service contract in effect. So, sometimes if you violate that contract by not doing what it takes to keep the car serviced, um, service contract is found to be void and they won't cover the costs of repairs. Also, there's a law, a federal law called Magnuson-Moss, and if you have a warranty, Magnuson-Moss may come into play, and that overrides what a contract would say. If they can't say it's as is if you have a warranty. Um, so again, Magnuson-Moss may apply to certain situations with service contracts or warranties.
Just to rephrase this whole thing, normally when a merchant like a car dealer sells you something, what they're selling you comes automatically with a guarantee that it's good quality and that it works. That's the way the law's set up. The law says that when a merchant sells something to a consumer like you, it's got to work. It's got to be in working condition. But there's an exception to that, and that's if the words as is and maybe some other language are in the contract. So that guarantee that's in the law that says it has to be in good working order, it has to work. Um, if the contract's written a certain way, then there's an exception to that. But the exception to the exception is what we're talking about here, basically if there's a warranty. So the default rule is they have to sell you something good. And the exception to that is that it's the as is thing. And the exception to that is if they've sold you a warranty. That might have been clear as mud, but oh well, let's move on. So now we're getting to sort of the trump card, I guess you could call it. No matter what the dealer does in terms of what they put in their contract and what they've done with the warranty, maybe they've made all kinds of guarantees and or maybe they've done everything they can in their written material to sort of tell you, no, we're not responsible for anything about this car. You're taking all the risk onto yourself. Even if they've done all that, there's still one last legal right that you have that might let you cancel the sale of a car that you bought that turned out to be junk. And that's revocation of acceptance, which is sounds very legal, and it is very legal. The if so I'm just going to rephrase. If the dealer sold you your car as is and says no returns, you still have legal rights if the car turns out to be junk. you can revoke acceptance of a defective car under certain circumstances. That means you can take it back to the dealer. So, as we mentioned earlier, once you drive a car off the lot, you're saying legally, essentially, that you've looked at the car and you've seen that it's in good condition and you're accepting it and you're taking it home. But revoking acceptance is undoing that process of, you know, taking the car off the lot, bringing it home, and all that stuff. So, when can you revoke acceptance? When can you cancel the sale by saying, I know I took the car, but I'm trying to undo that? The default rule, as mentioned, is that when you buy a car, the sale is final. So, what are the two exceptions? There are two exceptions to the sale being final, even in an as is situation. First one, you bought the car and it had a serious hidden problem that you couldn't have found out about before you bought it. There was one client in the past who had an engine that, after they bought it, immediately started having problems. The same problem kept popping up month after month, even though they kept trying to fix it. And eventually, the engine just completely collapsed. There were something broke completely down, and there were metal parts all throughout the engine, which is never a good thing. And so that client had a hidden defect in his engine that popped up immediately after they bought it. But that hidden defect was something that they could not have discovered through a simple test drive. That latent problem in the engine that eventually led to its complete destruction. So the first reason why you might have a legal right to revoke acceptance is if there was something hidden in your car that made it no good, that you only found out about afterwards, and that didn't show up in a test drive. The second exception is if there was a serious problem with the car that you knew about before you bought it, but you bought it anyway because the dealer promised to fix it. So in that earlier example, let's say that the engine was making weird noises during the test drive before the client bought it, and the dealer said, "Look, okay, we understand that the engine's kaput, but we'll do work on it and we'll make it right if you buy the car." And then the client had gone ahead and bought the car. If the dealer went back on their promise, then the client could revoke acceptance at that point and cancel the sale. So basically, if you buy the car because of a promise to fix it, and then the promise falls through, you can revoke acceptance and cancel the sale. And that's the second main time when you can revoke. So let's say one of those two things happened. Either there was a hidden problem or there was a promise to fix that never got fixed. If you want to revoke acceptance, you need to tell the dealer that the car is broken and that you're canceling the sale. Do it in writing. That's very important. Send them a letter and make a copy of the letter you send. Use certified mail through the post office and keep the green slip. Certified mail is just basically tracking and confirmation for normal letters. Send the letter quickly. Don't wait. If you wait, your right to cancel the sale will eventually disappear, and it might pretty quickly disappear. The law says that you have to revoke acceptance within a reasonable time after you've discovered the defect, or you realize that you have the right to revoke acceptance. So if you wait too long, then some judge, when it comes time to go to court, might say that you didn't revoke within a reasonable time, so you're out of luck. That's why you've got to act on your rights quickly. And here are some miscellaneous tips for revoking acceptance. A big issue in revoking acceptance is that the problem with the car needs to be pretty serious. It can't be just it can't be a cup holder that you don't like the look of. It probably needs to be something that is a serious mechanical problem with the car. So you should get a mechanic to look at it and probably write something up that you should keep. You need proof that there's a serious problem with the car that you can eventually take to court if you need to. As you revoke acceptance in your letter, ask the dealer to fix your problem. that may be legally necessary for you to give the dealer the chance to fix the car before you try to cancel the sale. Um, One client I had recently who we successfully revoked acceptance for did everything right. She went to multiple mechanics and she tried her darndest to get the car dealer to fix the car on their own. But no matter how hard she tried, the car dealer refused. And so I felt very comfortable writing a letter to the dealer, getting them to revoke acceptance because she tried her hardest to make it work on her own without trying to revoke before trying to revoke. In your letter, tell the dealer where you are keeping the car so that they can come get it. Ideally, they would let you drop it off on their lot and return it, but most dealers don't let you do that. So at least tell them in the letter where they can come get it.
As Ben said, you have to give the dealer the opportunity to repair the serious mechanical defect as part of revoking acceptance. And sometimes I had a case once where my client, after purchasing a vehicle, um, had problems. I think he lived in Cookeville, and he lived, he bought the vehicle in an adjoining town like 20 miles away, but on the way home, the vehicle started making horrible noises. And so he takes it back the very next morning at the time the dealership opened. And the dealership agreed to fix the car. Um, so they kept it for quite a while and told him that it had been repaired. When he got it back, he continued to have problems, but he did not have another vehicle, so he continued to drive it, but not for very long, not for an unreasonable amount of time. And then he heard that there was a recall of his vehicle make and model. So he takes it to the actual um, dealership that sold, like a Ford dealership, for instance, and he bought a Ford, but not from a Ford dealership. So he takes it to, for example, the Ford dealership, and asks them in the shop about the recall. And they tell him, well, no, this recall doesn't apply to your car, but we're familiar with your car. The dealership where you purchased it brought it here to be repaired. But when we told them it needed a brand new transmission and some other work, and we gave them the estimate, which amounted to $8,000, they decided that they would not have it repaired. And so he learned that way that the repairs that needed to be made, um, that were the reason he took the vehicle back to the dealer where he purchased it, had not actually been made. So we filed a lawsuit and were able to get them to take the vehicle back and give him return his money and pay him damages for that act of deception.
So that's revocation of acceptance, a powerful legal right that you might be able to use if you're under certain circumstances. But where does the bank? We've been talking about the dealer all this time. What about the bank? The bank's the one that's sending you all these bills for the loan on your car. Sometimes you get financing through the dealer, but sometimes you get a loan from the bank. A bank or lender that gives you a loan to buy a car has to honor a legal revocation of acceptance just like a dealer does. So if you revoke acceptance under the slides that we just talked about just now, if you revoke acceptance to a dealer, the bank has to agree. Bank has to go along with that if it's a legal revocation. Um, and in fact, they have a bank or lender is subject to all legal contract defenses and claims that you might have against a dealer. So if you're suing a dealer for various things related to the contract, then you can also have those claims against the bank with some limitations. But basically, if you have a legal right or claim against the dealer, normally that applies just as well to the bank or lender as well. So when you revoke acceptance with a letter, like we talked about a few slides ago, you should send a copy to the bank so that they know what's going on. So now, just to finish the presentation off, we wanted to talk about some miscellaneous topics that often pop up in car cases. And the first one is the fact that dealers will often lie about buyers' incomes. Why would they lie about your income? Well, because dealers want you to qualify for loans. If you buy a car from the dealer and the bank gives a loan on the car, then the dealer's gotten their money and the dealer's all good. So if you can get approved for a loan, then that's really good for the dealer because they've finished the sale and they've gotten their money. So what does that mean? It means that some dealers will fabricate income that they will put on a loan application to send to banks. They will lie about your income to make it more likely that you'll get a loan. We've seen that plenty of times in our offices that dealers have done. So, in order to prevent that, you should read the loan application before signing it. A lot of times, dealers will get you to initial your name. You should definitely make sure that what you're initialing is accurate so that you can be telling the truth on an official legal document like a loan application. And you should ask to see the loan application before buying if the dealer doesn't show it to you on their own. If it's never good to get into a car deal that you can't afford, and if the car dealer is lying about your income, then you're about to enter a car deal that you can't afford. So look for the loan application before you buy.
Yeah, we've seen a large number, unfortunately, of cases where our clients come in and they have only Social Security benefits or work a job and they have low wages, but the credit application reflects that they are making thousands of dollars, like $3,000-4,000 a month more than they're actually making. And like Ben said, the only reason that a dealer would falsify a credit application for that purpose is to get them approved for something and to set them up for failure. Another point I wanted to make is that you should never sign any document that is blank. And I have known clients to do that. They're told, you sign this, we'll fill it in later. Unfortunately, some people do that. And again, please don't do that.
So just some final miscellaneous topics that you might want to look out for. Things that you might want to talk to a lawyer about. Did the dealer sell your trade-in to someone else before the sale of the new car was final? That's happened sometimes. Sometimes we had a client who tried to buy a car, they traded in their car to buy a new one, and the financing fell through. They couldn't qualify for a loan. But the dealer sold their trade-in for a hefty profit. They traded in their car for $3,000 and the dealer sold it for $9,000. And the dealer said, "Tough luck." What the dealer did was illegal. So if that happens to you, you should probably try to talk to a lawyer about it. Another thing is just for the heck of it, look at the page of the contract that talks about monthly payments, the APR, in other words, the interest rate, and all that other stuff. There's a dedicated page to that called a TILA page, Truth in Lending page. Take a look and see if all the numbers look right. Is the down payment amount correct? Is the trade-in value amount correct? If those numbers are wrong on that TILA page that has all of the interest rate numbers and stuff, then you might want to talk to a lawyer about it. In fact, a lawyer might take your case for free. if that page is wrong. So take a look at it and see if everything's accurate.
Yeah, just to emphasize the first point on what Ben said, you may or may not know that often individuals are allowed to leave the lot with a vehicle, although the financing has not been approved. And what happens then is you're called back, and either while you're in the dealership, they might take the car, or they'll try to have you sign new paperwork with different financing terms. A larger AP, or higher APR. Um, but as being correctly stated, they're not supposed to get rid of your trade-in until the financing has been confirmed and a lender has extended the credit. I wanted to go back too and say something about revocation of acceptance. Now, um, lots of people buy cars from individuals, whether it's advertised online. Some people just park a car in a parking lot of a store or shopping center in their own yard. Um, so you might think that you can't revoke acceptance if you buy that from a private party, but you can. Um, a private party should not be able to sell you junk and get away with that either. There are some things like some warranties that are implied by law that don't apply to an individual or private party who's not a salesperson or a dealer, that do apply to dealers. But you can again revoke acceptance and try to get your money back um, when you enter into a transaction with a private party.
That thing Marla was talking about was signing financing paperwork and having financing fall through and then coming back to the dealer and signing a worse contract, maybe with a higher down payment. That um, that has a name. It's called a spot delivery scam. And you can Google spot delivery scam if you want to find more information about this practice, which is apparently pretty common. So if you're interested in looking out, in knowing how to look out for that kind of thing, spot delivery scam is what you can look for on the internet. All right, and that is the end of the presentation. Does anybody have any questions? Which I think I'm looking at the comments and can't see anything. But if you have any questions, please put them in the, I don't know how the Facebook thing works, but if there's a comment box, put it there. Okay, we're going to talk about some contact information, and once we're done talking about that, we'll see if there's any questions. So, last chance, guys. If you've got a legal issue, you can contact legal aid to see if we can help. As Marla mentioned at the beginning of the presentation, we have one lawyer for every 13,000 people who qualify for our services. So we may or may not have a lawyer who can assist you, but we may be able to give you some useful legal advice, or not legal advice. We may be able to give you some useful legal information, even if we can't be your lawyer specifically and sue someone in court. So if you need legal help, it can't hurt to call one of the numbers that's on your screen right now. There are numbers for the Legal Aid Society of Middle Tennessee's offices: Clarksville, Columbia, Cookeville, Gallatin, Murfreesboro, Nashville, Oak Ridge, Tullahoma. You can pick the closest city to you, and that will normally be the correct number. But if not, they will direct you to the correct office to call. And then there are other numbers for West Tennessee Legal Services, which handles most of West Tennessee except for the 4 counties around Memphis. Memphis Area Legal Services, which covers those 4 counties. And East Tennessee Legal Services, the offices of which you can see listed below. All right, and it looks like there are no questions even after that last chance. So thank you to everyone who is watching. It was good giving this presentation. I hope it was helpful to some people. Marla, any parting words?
No, just thank you for tuning in, and you have our contact information. If you have a specific legal problem that you would like to talk with any of our offices about, please call us.
All right, thanks again, everyone. Thanks, Marla, and have a
Thank
great
you.
evening, everybody.
All right. Thank you, Ben. Bye bye.